morning, Elbert.
Good morning.
As you know, there have been a number of changes at the Supreme Court recently, with Justice Gorsuch filling Justice Scalia's seat a little less than 2 years ago, and Justice Kavanaugh replacing Justice Kennedy just last fall. How might these new justices change the law and the way cases are litigated at the Supreme Court?
You know, as you know, Bill, it's always difficult to predict how new justices will act, even in cases where the justices have served as Court of Appeals judges for a long time, as Justices Gorsuch and Kavanaugh have. Two primary problems with that. The first is these circuit judges who are now Supreme Court justices aren't bound by precedent anymore, and so they will each have to determine how they're going to deal with principles of stare decisis. And second, both new justices now have the new power to influence the kinds of cases that they hear through the cert process. All that being said, I think there are at least three areas where we'll see some change. The first is the area of administrative law, and in particular, questions of deference to administrative agencies. The second, as many have observed, is we'll likely see the Chief Justice become more of a swing vote. And the third is we'll probably see, in constitutional cases, arguments of original meaning taking on even more importance than they had before.
Thank you. Albert, you mentioned administrative law. Could you elaborate on that a bit? In particular, how might the new court change administrative law and how those questions are litigated?
Justices Gorsuch and Kavanaugh in their previous lives were both highly critical of the court's current administrative jurisprudence. Justice Gorsuch, in a pretty famous, now famous concurring opinion called Chevron, the behemoth that needs to be faced, and Justice Kavanaugh, in some of his scholarly writings, had criticized a threshold question, Bill, that you know in many administrative law cases about whether statutory text is ambiguous, and he advocated for ditching that test entirely. And so with these two new justices, we can expect the court to perhaps be more aggressive in the ad law space, and we're already seeing two cases this term. The first is a case called Kaiser versus Wilkie, which addresses the Auer or Seminole Rock deference line of precedent. The court had previously declined several petitions asking the court to overturn that line of precedent, which has to do with the amount of deference given to an agency in interpreting its own ambiguous regulations. And the court is now poised to consider that question. And the second is a case about the physician's desk reference. It's a case about the statutory time limits on reviewing FCC actions, but I think it could be a sleeper involving Chevron. And then I think the last point to make on this, and Justice Gorsuch wrote recently on this issue, is in terms of Chevron, there now appear to be a majority who are pretty skeptical of Chevron once you add Gorsuch and Kavanaugh into the mix. And some think that might mean that there will someday be a decision that overrules Chevron deference, which, as you know, is the doctrine that says that the courts must defer to an agency's interpretation of ambiguous statutory language. But as Justice Gorsuch observed, the fact that there are now 5 who might overrule Chevron may mean that parties just stop relying on Chevron as much in defending agency actions, and maybe Chevron just sort of dies a slow and quiet death.
Interesting. Let's turn to one other potential change that you mentioned, that is the Chief Justice becoming the swing vote. What do you mean by that, and how might that affect Supreme Court litigants?
Sure. As most know, Justice Kennedy was known as the swing vote, which meant that his vote in close cases was often most in play and could most determine which way a 5-4 case might go. Many have suggested, and I think it's likely, that the chief will now take over that role in some cases. In the case of Justice Kennedy, he tended to be the swing vote in individual rights type cases, in where he was more likely than others to either side with Roberts, Scalia, Thomas, and Alito, or go with the other 4 justices. Most think that Kavanaugh is going to be closer to the 4 so-called conservative justices than Kennedy was, and if that turns out to be true, then I think you'll see the Chief Justice being the swing in federal power type cases, so cases that involve questions of congressional power and whether to strike down acts of Congress. The Chief has tended to show more deference to Congress than Thomas and Alito, and probably Gorsuch and Kavanaugh. One other point on the Chief being the swing, I think you may also see the Chief using his vote more judiciously or strategically in the certiorari process. Now, the technical power of that vote is a little bit less in cert cases, in the cert circumstance, than for the merits, because only 4 votes are required for cert. But as the Chief, he does have a lot of other means to influence that process. He is the one who speaks first when discussing cases on cert, and he's the one who votes first when discussing cases on cert.
Thank you, Albert. That was very helpful. What other suggestions or observations do you have for Supreme Court litigants or those laying the foundation for a Supreme Court case?
Sure. I'd say I have 2 final observations. The first has to do with the point I made earlier about original meaning in constitutional cases. Most have expected that Justices Kavanaugh and Gorsuch will take original meaning type arguments seriously. Justice Gorsuch has certainly shown in the past 2 years that he takes those arguments very seriously, having joined opinions by Justice Thomas and even having adopted originalism arguments that Justice Thomas hasn't. So I think what this means for litigants as they think about coming to the court is that there are at least 2 justices who take those arguments seriously, perhaps whose votes can't be gotten in constitutional cases without original meaning type arguments. And what this means is in the lower courts, those litigants should be considering preserving originalism type arguments and doing the substantial work and research that's required to present those arguments fully. The second observation I have is for those litigants who think that the Supreme Court may present an opportunity to attack longstanding precedents, I wouldn't wait too long. I think it's always important for a petitioner to carefully vet their cases. You want to make sure that there aren't unintended consequences, that there aren't lurking vehicle or procedural problems in your case. But as Justice Scalia's untimely death showed, whatever it is we think we might know about the Supreme Court today is not necessarily going to be true about the Supreme Court tomorrow. And so if you're a litigant who thinks that there's a chance to strike here, I wouldn't wait too long, and I wouldn't let the perfect be the enemy of the good.
Again, very helpful. Thank you for your comments, Albert.
Thanks, Bill.